Silence in the court.
Order.
Objection, Your Honor.
Sustained.
Right, that's not what being a commercial lawyer is about. So what does it involve? It's about business and contracts. Contracts are the nuts and bolts that hold the global business engine together. Without them, business doesn't work. And who knows about contracts? Lawyers. What does business do? It involves deals to buy, to sell, to cooperate, to separate. Deals on price, on timing, on ownership, on value. And when it comes to big business, we're talking big deals, FT front page. But what does it take to make these deals happen? Let's look at the anatomy of a deal. Okay, here's the deal. Enterprising Capital, a UK-based private equity fund, wants to acquire the Motion Group, a manufacturer of parts for the automotive industry, with operations in the UK, US, Germany and Italy. Enterprising Capital thinks it can improve Motion Group and sell it on at a profit. That's broadly what private equity funds do. Motion Group's current owners want around 950 million for the sale. As a lawyer, the first thing you're going to need is an understanding of the financial side of deals, and in particular, where the money comes from. This is going to be a leveraged acquisition. What does that mean? Enterprising Capital doesn't actually have 950 million lying around. So, instead, it plans to buy Motion Group by investing around 350 million in shares or other equity through a fund it has raised from investors, and by borrowing the remaining 600 million from banks. We call this type of borrowing debt finance. The idea is that by running Motion Group better, Enterprising Capital will generate higher revenues from the business and use these to service the interest payable on the 600 million of loans. Then, in a few years' time, it will sell Motion Group for a higher price. Its goal is to make Motion Group worth not 950 million, but 1.3 billion. That way, when it sells, Enterprising Capital can pay back the bank 600 million and see its own stake of 350 million double to 700 million. Now that's a tidy profit. Everyone is happy. But where do the lawyers come into this? Okay, so who is buying the Motion Group and borrowing all that money? Enterprising Capital? No. The first thing they will want to do is establish an acquisition vehicle, a separate new company to own and run Motion Group. And that's where the lawyers come in a big way. What kind of company? Limited company? Limited partnership? Where should it be registered to be both tax efficient and allowed to do the things that Enterprising Capital wants it to do? Which is to access the revenues of the Motion Group business so that Enterprising Capital can pay the interest on its debt. This is important because there are differences in how payments to an acquisition vehicle are taxed in different jurisdictions, so specialists in tax law will be needed. Plus, there are differences between jurisdictions in terms of releasing cash from the target group to pay the interest and repay the debt. Germany, for example, has much more restrictive laws on the extent to which companies can do this than the UK, so international expertise in banking law is also required. Let's say, following the legal advice, Enterprising Capital settles on a limited company registered in Luxembourg for its acquisition vehicle. The corporate lawyers better get cracking on setting that up. This deal has to happen fast because Enterprising Capital has a small window before the Motion Group is put up for an auction sale and they could lose out. And they better make sure that the banks like it or the lending just won't happen. But hang on, what is it exactly that we are buying here? A car parts manufacturer? Yes, got that. But what does it own? What are its liabilities? Who does it have contracts with? Is anyone suing it right now or about to? Answering these questions and 1,000 others is called due diligence, and it's what lawyers, and especially, should you become one, trainee lawyers do. It's where the lawyers kick the tires of the acquisition target to see what it's really made of. Does Motion Group own its intellectual property, its brand? Which suppliers have provisions in their contracts to pull out or reprice in the event of an acquisition? It's the lawyer's job to find out. What about the people involved? Because when one company buys another, it also buys the people who work there. If Enterprising Capital wants to retain the senior team, then employment and benefit lawyers will get to work, understanding and migrating their salary packages. At the same time, they'll have to look at the labour laws in each of those 4 jurisdictions. Many private equity funds looking at a business will restructure it to make it more efficient. What employment issues will they encounter? What can they expect from the unions? Better to find out now. Okay, let's go. But wait, is there an antitrust aspect to this transaction? What other businesses is Enterprising Capital involved in? Will the sale trigger an investigation by the European competition authorities? Perhaps they'll demand that Enterprising Capital divest some assets to level up the playing field. Which ones? How much will it cost? And is it worth it for this deal? If all that goes well, then we're moving towards what's called the execution phase, with both parties focusing on the Sale and Purchase Agreement, or SPA, which in this sphere is the king of contracts, the agreement under which Motion Group's current owners agree to sell it to Enterprising Capital. It's the lawyers who will draft it, negotiate it, redraft it, renegotiate it, and finally agree it. There will by this time have been adjustments to the price. This is a typical feature of negotiations, and the SPA will also contain provisions for further adjustments to the price once the deal has completed. On what basis exactly? Value of assets? Level of cash or debt? When all the commercial points have been agreed, the day will come when the SPA is signed. And relax. No. Now there's a lot of work for the lawyers to do in simply making sure that all the right documents are in the right place to be signed. And if that sounds like a lot of paperwork, it really is. Share certificates, licenses, employment contracts, loan agreements, the bank's conditions for lending. The big day will be a closely choreographed chain of signings and verifications, last-minute negotiations and amendments to contracts, and then, finally, the deal will be signed. There's usually a little celebration, by this time, some very tired lawyers. And that's because at every step of the way, it's been the lawyers who've made it happen. Now it's up to the people at Enterprising Capital to implement their strategy and realise the value they saw in Motion Group. But that's another story. And that, in a nutshell, is the anatomy of a deal.